Viewers, you had heard so far Professor Rose Varghese speaking about and highlighting the meaning, intent, purpose of aspects like mens rea, motive, intent, preparation. Now, would you like to move further with your presentation with regard to the crimes and the other part?
Yes. To prove the point of intention or to distinguish it from civil law, I was giving an example of a person driving to go for an interview. Now I've given you a second example where I had an enemy. We hated each other. Maybe he and I loved the same girl. So I want to get rid of him. I want to get rid of him. And I plan, preparation. I observe him. He takes early morning walks in Delhi roads, winters when it is 2 degrees temperature. While he's taking an early morning walk, I quietly come out, take my car out of the car shed, and I follow him slowly, and suddenly I hit the car against him. Then I reverse my car, and again I run over him. A third time. Thrice I run over him with my car. Like in the other case, the weapon used is the same, the car. Because in criminal law, you cannot read the mind of a human being. You can only look at the nature of the crime, the circumstances. What was the weapon used? Was it aimed at a vital part of the body like the temple or right onto the chest? That way, if you look at it, here also the same weapon is used, a car. But here, I've run over him thrice. The man dies. But even in my first instance, the man died. So if you are a judge, I'm trying to distinguish the reaction to crime. If you are a judge, in the first case, what kind of punishment will you feel like giving that person who wanted to join the law firm? And in the second case, what kind of punishment do you want to give the man who ran his car over the other man? This is my question to the teachers. And I expect discussion, no doubt
and to
about
justify.
it. No doubt about it.
Yes.
Now, in the first instance, all of you tend to give answers like, we can fine him, we can ask him to pay.
Relatively lenient view.
Compensation.
Yes.
Why? Criminal law is more punitive in nature, whereas civil law is more compensatory in nature. There is punishment in compensation also.
Yes.
You may even say pay 10 lakhs. But it's meant to compensate him because his hospital bill came to 8 lakhs.
Yes.
You got my point.
Yes.
Whereas here, you literally want to see this man behind the bar and you want to give long incarceration. Why? Crime is there to prevent society from
repeating it, yes.
So you have to give that's why the preventive theory people argue for long incarceration, many years in jail. And if it is, like we call it, the rarest of rare case or a horrendous crime, pre-planned, then you would even ask for death penalty. But before going to death penalty, when you talk of crimes, I spoke of intention and knowledge. To teach intention and knowledge and the sections in the IPC which deal with murder and culpable homicide, the best way to understand the distinction is not by telling the students the dictionary meaning of intention, knowledge, this, or reading out the section. Because if you read section 300, which defines crime, Clause 3 says, intention to commit a crime, which is to commit an offense, which is sufficient in the ordinary course of nature to cause death. Whereas Clause 4 of Section, I would put bullet points on the board. I don't believe in long sentences. Bullet points on the board will show Section 300, Clause 4, which says what is knowledge. Knowledge would say, Clause 4 would say, compare 300 Clause 3 and 300 Clause 4.
Okay.
When 300 clause 3 is saying that what you have done was sufficient in the ordinary course of nature, you intended what is sufficient, it's a clear case of murder because you intended. But clause 4 says, you knew, the word used is knowledge. You knew that it is so imminently dangerous that it will, in all probability cause
result
death.
in. Yes.
Cause death. So that's the degree of
Yes.
the offense.
Is to be appreciated.
Of your intention. Because I tell my students, the mind of man is so inscrutable that not even a devil can delve into its deep waters.
Okay.
You have to prove what was the intention and what the person only had knowledge. Now, to teach murder and culpable homicide, I always start with giving my students a case to read. I will tell them, go and read Virsa Singh's case.
Okay.
I'll put the name and the citation on the board. Read Virsa Singh. All of you should read it. I will just pick up any one or two and ask you to come forward. At a later stage, I assign it to 3 students. 3 would be public prosecutors, 3 would be defense counsel, and 3 students would sit as judges.
Okay.
When they read that case, they will understand the difference between this criminal law and...
That's sort of a play.
Always.
Role play has to be assigned.
Moot court in the classroom.
Yes.
And I've told my students, don't go for a moot court unless you have sat for a moot court, had it in your class itself. And for murder, culpable homicide, they have it as a moot court. Then one student will start prosecution, your lordship, if it's a lower court, your honor. This is the case of in this case, the accused stabbed another man on the abdomen. Virsa Singh's case. The accused stabbed somebody on the abdomen and then ran away. Then he thought, oh, the fingerprints, that's why I said they should learn a bit of forensics. The fingerprints will be there on the knife. So he rushes back and tries to remove.
Fingerprints.
No, fingerprints will be there on that, the spear which he has used. In Virsa Singh's case, a spear was used. He tries to remove the spear, and in the process, the intestines get damaged.
Okay.
Now, what was the intention of the accused? Will you believe in the court, the defense counsel argued he had no intention to murder? Because if he had intention, he would stab several times. But it was one single stab on the abdomen.
May not be adequate.
That's the defense counsel.
Yes.
Now, who decides? That's a very important question when you're deciding about murders. Who decides whether it was adequate or not?
Yes.
The accused will say, I stabbed only once, so my intention was not to kill, only to hurt, or to cause grievous hurt, or section 326 IPC, causing grievous hurt with a dangerous weapon.
Yes.
That's it. But the prosecution could prove how. The medical evidence says he twisted the spear and the intestines were damaged. He remained 20 days in jail, in the hospital.
Yes.
So there again the defense would say, he didn't die at once, so that was not my intention.
Yes.
But the prosecution proved that he didn't just die out of a heart attack or kidney failure. It's because of your stab.
Right.
And that resulted in his death.
Yes.
It's because of the injury caused to the intestine.
So this sort of clear understanding step by step, going into and asking questions yourself, perhaps that habit should be inculcated and
By
teachers.
Teachers in criminal law, constitutional law, all they should teach case method of study.
One more, yes.
Sir, each student is asked to read the case.
Okay.
Even I would start by asking those who have not read, please stand up. Because I expect them to read when I tell them to. And they do it in my class. Now, when they have read the case, they will understand the intricacies of the law.
And they may sort of question the faculty to clarify their doubts.
Then they enjoy what is murder.
Yes.
They understand it better, not enjoy murder. They'll enjoy the subject better because now they've understood.
Right.
When is it murder and when is it culpable homicide? But if your intention was only likely to cause death, whatever you did was
Yes.
not sufficient, but it was likely, then it becomes culpable homicide.
Homicide.
But even if he knows that it is so imminently dangerous, it is murder. For that, I tell my students to read Diraja's case.
Yes.
You know, so it's a very strange, interesting case, old case, but I still refer to that case
Okay.
when I refer to the difference between intention and knowledge.
Okay.
Quickly, I'll tell you. There again, the students would be asked to read it. So they would follow while we have the interaction. Diraja ran out of her house. She was fed up with the life she was leading. Her husband treated her very cruelly.
Yes.
One day, with her child in the hand, 6 months baby, she was going away to her village. She didn't want to live with them. While she was walking, it was a village area. When she turned, she could hear footsteps, so she turned. And her husband saw she and the baby are not in the house. He was following her. He used to beat her up badly. She was literally afraid of him. So when she turned and she saw him, she walked faster and she saw a well and she jumped into the well. Now, students, please tell me. Teachers, please tell me. Did she have the intention to kill her baby? Did she think, oh, I don't want to keep this baby now? Did she say, oh, let me get rid of this baby? Or was she going to a safe haven with the baby? Or, if not intention, so everyone naturally says, no, naturally the mother does not want to kill the 6 months baby. Then what was the state of mind? You have to read the mind of the person. She knows
Yes.
that what she did is so imminently dangerous that it will, in all probability, cause death. With a 6 months, I'm not talking for 6-year-old. Jumping into a well with a 6 months baby. Now, it is only knowledge. But it is murder because what she did was so imminently dangerous that it will, in all probability, cause death.
Yes.
So it's knowledge. Now, Section 300 has a next clause which says, provided she had an excuse for taking that risk. If so, it becomes culpable homicide. Otherwise, it's murder.
Yes.
Because it's only knowledge, no intention.
Yes.
But it was so imminently dangerous. So it is murder.
Yes.
But provided what she did, she had an excuse. Now you tell me, did she have an excuse? So everyone sort
That's
of...
how they approach
Yes.
has to
And
be
they've
there.
read the case.
Yes.
See, now suddenly if I'm talking to a teacher who's not read the case, anyone,
Yes.
they would take time to understand what I'm trying to
This
say.
is something very significant.
But when they've read it, that's why case method of teaching criminal law, constitution, I would say,
advisable.
should be
Yes.
there. Now, when they've read it, they would say, of course, she had an excuse. Because out of fear, she looked around and jumped into a well. It was not pre-planned.
Yes.
And it was knowledge. So it is murder, but she comes under this. Because provided she had the excuse for running that risk. Now, this happened in Diraja's case.
Yes.
Through this case, they will understand what is intention, what is knowledge. And even if knowledge is so imminently dangerous that it will in all probability cause death, still this excuse brings murder to culpable homicide.
Quite right.
Now, what is the actual difference between murder and culpable homicide? In murder, it is nothing but the intention was to cause death.
Yes.
In culpable homicide, it is only likely to cause death. Because we really want to ensure a person is dead. Like my own example of the person running the car over a human being thrice. Your intention is clear. So in criminal law, you have to read the mind from the nature of the act. And the weapon used. Was it in a vital part of the body? All this. Now, other than Diraja and I spoke of Virsa Singh, one question always arises. Because now we go to a bit of penology where the judge has to decide what punishment to give.
Yes.
In a case which is a horrendous pre-planned murder, and you are a judge listening to it, like the Nirbhaya case, you won't just tap the person on the shoulder and say, okay, please don't repeat such things.
Yes.
You will go for
Exemplary.
exemplary punishment. It's the exact word you should use in the classroom. Exemplary punishment. You will go for death penalty. Now, as law teachers, you should also know that the constitutionality of death penalty has been challenged in our courts umpteen times.
And there is the leading final case which gives finality.
Lot of, sir.
Yes.
It started off with Jagmohan Singh, Rajendra Prasad's case, Bachan Singh's case, K.R. Singh's case,
Yes.
Tarlok Singh, all cases where death penalty was given, but where people have challenged the constitutionality. Why? Saying Article 21 gives us the right to life. How can you give a punishment taking away the life of a person? But Article 21 Constitution, read it out to students. It is not just declaring death penalty outright. There was a procedure established by law.
Yes,
okay?
yes.
So there you just mention Article 21. Our Indian Supreme Court has consistently held from, I would say from Jagmohan Singh, Rajendra Prasad, Bachan Singh, Machhi Singh, Tarlok Singh, in all these cases, the courts have consistently held that death penalty is not unconstitutional.
Yes.
But in Bachan Singh's case, they said, okay, we can give it in the rarest of rare cases.
Quite right.
Now, how do we know what is rare? So what you might think is rare, I might think differently. It's like the concept of obscenity or morality. What you think is immoral, a younger generation, our students would say, ma'am, what's immoral in that?
But they have given certain illustrations in that.
Yes. In Machhi Singh's case, the court laid down guidelines when you can call it the rarest of rare case. But in this context, the Indira Gandhi murder case, the judge reiterated that we are calling it a rarest of rare case, not because the Prime Minister of India is murdered.
Yes, and because of those.
The person on whom she reposed confidence turned round and killed.
And shot her.
Well, that's the way the courts have tried to explain all these intricacies of the law.
Right.
And then there are general defenses. There is now the new law. Earlier, all the sections were there on crimes against women.
Yes.
Spread out. But, see, the new law has put it all more or less in one chapter, that is all. But the same wording all continues.
Has been.
Yes, quickly about crimes against women. People always talk about rape cases, that one is rape, this one is rape. But teachers of law should remember and realize that crimes against women is not just all rape cases. I'm now talking about the old Indian Penal Code. Just the section number has changed, the same law.
There are variety of cases. Yes.
292, obscenity, obscene laws, selling and buying obscene books. Eve teasing, 294. 304B, dowry death. Innumerable cases of dowry death. 354, outraging the modesty of a woman. It's not rape. But there are facts of cases which is worse than rape. That is why they have now, and even a little earlier, with various amendments.
Should not be lost sight of.
No, 354, they've enhanced the punishment for outraging the modesty. They've changed the definition of rape. That even certain acts can be treated as rape, come within rape. And 354 has gone through major change. There, in this context, you have to bring to the notice of the students that criminal law is not just all the 511 sections drafted by Lord Macaulay, but in 1983, criminal law was amended after the Madura case.
It has kept pace with the society's
happenings.
With the happenings in this.
Madura case, 1983 amendment, 2013 amendment, 18 amendment, all came after the Nirbhaya case. Now they included acid attack as an offense. Even 354, even rape with murder, they have given death penalty. Sorry, for 354, they have given enhanced punishment. Much different from what it was from the old law. Why? Because these crimes were happening on a daily basis.
So this is where the courts have to keep in mind the prevalence in society and the evils that have to be dealt with sternly.
How rampant is a particular crime based on that sternness. And there are so many cases. If I I would then move on to, with each topic, I would go to the cases.
Yes.
Dr. A.S. Anand was the Chief Justice of the Supreme Court, retired.
Yes.
Before that, he was Chief Justice of the Jammu and Kashmir High Court. He
Yes.
was Chief Justice
Yes.
there. While he was Chief Justice there, in one case, what he has said is crimes against women should be treated with an iron hand. He says you should go for a very, very exemplary punishment to give the message to society that we cannot take it light, treating
Yes.
women with indignity. Very nice judgment, very nice
Okay.
judgment. So what I'm trying to say, there are a lot of cases behind all this. There is section 312 to 316 of the IPC forcing a woman to cause miscarriage. Is it a joke? While they have their love affair, he will tell her, I promise you I'll marry you, have sex. And if she gets pregnant, he says, come on, abort the child. So there is IPC
Yes.
312 to 316. There is 372, sir. Imagine selling and buying minors for prostitution.
Right.
That has found a place. Then, of course, 376, rape. And now with the new amended Criminal Amendment Act 2013, they've brought in stalking as an offense. Because now, computer and all the
faculty
cyber
would make
crimes.
a mention, yes, of these newer
New laws,
new
voyeurism,
offences.
stalking,
Yes.
these are all new laws. And the Sexual Harassment Act
Yes.
also came
At
about.
workplace, yes.
And child offences were increasing.
Yeah.
So now we have POXO.
Yes.
So laws have really kept with the change. I would say we have the laws. Now then why is it happening every day?
We would stop here
Yes.
and then
Yes.
wind up.
Yes.